Thanks so much for joining us for CBN News Today. I'm Ephraim Graham.
And I'm Charlene Aaron. Conflicting court rulings create more controversy for Obamacare. Tuesday, a federal appeals court dealt a major blow to the Affordable Care Act. But just hours later, another court issued an opposite ruling. Caitlin Burke tells us what it all means for the president's health care overhaul.
It's a decision that could potentially derail Obamacare, and millions of Americans will pay the price. When Obamacare was first pitched to low and middle-income people, the plans offered on healthcare.gov were only affordable because of subsidies. That's federal aid to help pay the premium. But the U.S. Court of Appeals for the District of Columbia Circuit ruled that for 36 states, those subsidies are illegal. The healthcare law says the government can only provide subsidies for healthcare sold through the state exchanges or online marketplaces. But 36 states were unwilling or unable to set up an exchange that would have made them eligible for those subsidies. So the IRS set up a rule that allowed the federal government to pay the subsidies.
The IRS has already been relatively politicized, was trying to cover for the administration here in a law that was possibly just poorly drafted. Possibly they thought all the states really would enact these exchanges.
The D.C. court ruled that the IRS action went beyond the law, and so the federal government can't legally pay out the subsidies, which could make Obamacare policies too expensive for people who depended on that money from Washington. Meanwhile, a Virginia federal court came out with a different ruling. It said the IRS correctly interpreted the will of Congress by allowing subsidies in all 50 states. Now it appears that once again, the fate of Obamacare is likely to be in the hands of the Supreme Court.
I think there's a good chance that the Supreme Court will come to the common sense conclusion that this is another example where federal does not mean state. You can't rewrite this law just to make it say what you wish it had said.
Caitlin Burke, CBN News.
And joining us now with more is Travis Weber, director of the Family Research Council Center for Religious Liberty. Travis, we've got two conflicting rulings here. Let's begin with the D.C. Circuit Court ruling. It appears to seriously undermine Obamacare. How significant is that ruling?
Absolutely. I think it does significantly undermine Obamacare. You know, at issue was one little phrase established by a state. And the court looked at that and said, we can't interpret state to mean anything else in this case. Courts do look at legislative history and circumstances surrounding the drafting of legislation, but that's only to supplement the text of the statute. And here, it's just clear enough. It can mean nothing other but a state.
Well, Travis, we know the Supreme Court has already jumped through some pretty big hoops to declare Obamacare is legal. So even if these rulings end up at the high court, will it really matter?
Well, it will matter. You know, from a legal perspective, the issues are different, and the court will be obviously taking a look at those legal issues. Now, there may be some political and a general philosophical sense surrounding this whole fight and the framing of the fight in which the court may want to uphold the law and achieve a result similar to its last big ruling on Obamacare when the individual mandate was challenged. However, the court will be looking at the legal issues, and so I think there's good reason to believe that the court will agree that the text of the law and the meaning of the word state can't really mean anything else.
Well, today there have now been some major rulings against Obamacare, like the Hobby Lobby ruling. But are they about the law itself, or are they about the way the Obama administration has been implementing it?
Well, I think I would probably answer that with it's about both. Certainly there are a lot of problems with the implementation of the law. The fact that there are those problems is compounded by the size and scope and what the law is attempting to do, which is rather novel, in its effects and intrusion into so many areas of American life. I think many will accuse the courts of simply enacting their political will in the decisions. I think, however, we've seen a lot of fair decisions in which the law is examined, and though the administration would want us to believe otherwise, this is simply a matter of upholding the rule of law.
Does Obamacare threaten religious liberty in any way?
Well, I think it absolutely does, not so much in this decision, but in some of the other decisions we've seen in the Hobby Lobby decision and elsewhere. Next up, we're going to have some of these cases involving nonprofit challenges, nonprofit entities challenging the so-called accommodation under the law. And, this, again, is an effect of Obamacare, and it's one in which the administration wishes to enforce its view of religion on individuals. And, this is something we're going to have to continue to watch.
Well, in the wake of the Hobby Lobby ruling, some in Congress are trying to actually rewrite the Religious Freedom Restoration Act. How dangerous is that?
Well, it's very dangerous. The Religious Freedom Restoration Act is a strong resetting in statute of a constitutional standard of free exercise of religion. One would not think that's a controversial idea, yet now you have folks in Congress attempting to modify that and suppress those rights and gut that act, basically, in order to advance and force folks to pay for other methods of contraception that many believe end life.
All right, Travis Weber, thank you so much for your time. Much appreciated.
Thank you.